Hi, today is Friday, February 27th. I'm Cindy Allen, CEO of TradeForce Multiplier, a global trade consultancy service. We handle everything from high-level strategy and technical issues to the more mundane classification and risk review types of services. Welcome to Simply Trade Cindy's version, where I base an international trade update on a Taylor Swift song. Brought to you in association with Global Training Center. Today's song is All Too Well. We'll get into that in a moment. But first, what happened this week in trade? Well, today has been a week since the IEEPA tariff legislation, the Supreme Court decision came down. There are lots of questions, lots of open issues that we are dealing with 7 days past. But let me give you a general update. Legislatively, there are 3 bills regarding IEEPA refunds that have been introduced in the past week. 2 are for everyone getting a refund. Some are tying that to giving refunds to consumers, which if you're in international trade, you know how difficult that might be. That might not be the best way that we want to move forward. One is kind of against it somewhat and does also tie it to refunds to consumers. So we'll see where those are headed in the future. We are still under a DHS shutdown due to budget issues. As we saw last week, TSA PreCheck was supposed to be shut down. However, DHS did revoke that and TSA PreCheck is still active. However, global entry is not active due to staffing issues as communicated by DHS, and that is directly tied to the lack of a budget. We have several other trade bills that are pending that I've spoke about before: removal of the first sale, removal of non-resident importer of record, a licensing program that we don't really understand the details of. All of those bills, including the IEEPA bills, are unlikely to move. I think if anything moves in the next couple of weeks, it's likely to be IEEPA refunds, especially if we see a decision come down regarding refunds and ruling that refunds are not going to be issued. So I think that is a good opportunity for Congress to act, but absent that, I don't think it's going to go anywhere. CBP specifically, most of the personnel are in place and they are working. They are working without pay, so let's all be nice to our CBP friends, as well as our TSA friends that are working without pay during the shutdown. They are limiting their interaction with the trade as they have determined this to be non-essential business. So any appearances at conferences, any meetings, they really are not scheduling those and are canceling any that are already in progress. We're still awaiting further guidance on Section 232 valuation, specifically for the derivatives on steel, aluminum, and copper. There has been some conflicting information that's been put out, conflicting in the manner that CBP has issued guidance that's not in keeping with what the actual executive order says. Many trade associations have come together to ask for clarity in that issue, but we have not yet received a response, so stay tuned for that. And as far as the administration goes, we're still seeing new deals are being signed, new trade deals, but those deals are switching to Section 122 instead of being issued under the IEEPA authority. They are also signaling that there will be an acceleration of the remaining 232 cases that are under investigation and some 301 investigations that have been started. As we all know, the 232 and the 301 trade deals actually have a structure and do have a timeline. They require investigation, they require input and notice. So we in the trade at least have an opportunity to provide input into that. Whether that is successful in taking the administration away from taking these actions is another thing, but at least we'll have an advance notice of those coming into play. No more Friday night announcements that take effect over the weekend. So that brings me to why All Too Well. So what spoke to me about the lyrics of this song is that even though IEEPA has been a roller coaster ride for the trade, now that it's gone, we are really in uncharted territory again. And the lyrics that really I thought were applicable was, and I know it's long gone and the magic's not here no more, and I might be okay, but I'm not fine at all. I don't think anyone in the trade is fine. We have so much uncertainty right now. And if you are a service provider, if you're an attorney, if you are a consultant, we've gotten many phone calls. What do I do? What's next? What's coming? The only thing we know that is clear is IEEPA's gone. The president does not have the authority to issue tariffs under IEEPA. What's not clear is what's next. If, how, when refunds are going to be issued. I've listened to no less than 5 webinars and meetings regarding what happens now that the IEEPA Supreme Court decision has been announced. We don't know what's going to happen next. So I thought I'd kind of break down the if, how, and when. First, talk about the if. The Supreme Court remanded the decision for refunds to the lower court, and that will eventually make its way to the Court of International Trade that has jurisdiction over trade matters and customs matters. So will CIT rule that the refunds must be issued? Can they rule that there won't be refunds? The prevailing legal opinion has been that there is no legal recourse to withhold refunds, but it's which refunds and how those refunds will be obtained that are the big question right now. I know it's long gone, but the magic's not here no more, so we don't know what the magic means going forward. So that brings me to the how part. There are some pretty detailed legal arguments going on between all of the trade associations and the trade lawyers and different opinions. The question seems to revolve around a couple of things. And at its basis, will the decision from the Court of International Trade come down to a decision under 1581I, which is equitable jurisdiction, meaning everyone gets a refund, or is it 1581A, meaning that the court would only rule on denied protests? So why should you care about that for the legal perspective? What it really does is define the how you would get your refund and if you would get your refund. So should you file a protest? If it comes down under 1581A, you're going to have to file a protest. Will that be denied? If it's not denied, you'll get your refund. If it is denied, it would go to court. You'd have to file a court proceeding and they would actually rule on that. So it's an open question. Should you go to court? Are you going to be required to go to court? Are you going to have to file an action in the Court of International Trade? We heard a few days ago that FedEx has filed an action in the Court of International Trade because they want to protect their right to a refund. We do know that post-summary corrections, there's been several brokers who have tried that on behalf of their clients and they're being rejected. So we wouldn't recommend post-summary corrections be done right now because Customs isn't even accepting them. What I do recommend is that you talk with an attorney. Attorney can walk you through all of the different ways that the court action might be taken. They can talk about your options. They can talk about what do you need to do right now. If you don't have any entries that are going to liquidate before the Supreme Court process is finished and it goes down to the Court of International Trade, let's say you have a few months, you may want to just wait. You may want to try to be patient and not file any action at all. But what you might want to consider if you have entries that are liquidating right now, or in the next 32 days, you may want to go ahead and file that protest just to have a placeholder to make sure that you're preserving your rights. And why do I say that? Why did I say 32 days? Well, when the Supreme Court remanded that back to the lower court, what happens is that the Supreme Court, in normal times, the government has a 25-day period where they can ask for a rehearing. And what I heard in all of these webinars is that very, very rarely happens. And they don't expect it to happen in this case because there's been signals from the administration that they will abide by the court's decision. So we don't expect anything to happen in those first 25 days. Then there's a period of about 7 days where that communication and administrative period of time. And then once that time passes, which is 32 days, it goes to the jurisdiction of the court, the lower court, and the Court of International Trade. So the timeline is about 3 more weeks. So if you don't have any entries liquidated in the next 3 weeks, you have some time to make some decisions. Go have a coffee, have a glass of wine this weekend. Make sure that you pack your patience, as my mother would say, because we do know this is going to be a long haul. This is not something that's going to be adjudicated in a few weeks. It's probably going to take months. It could take a year or more. We're hoping it doesn't take that long. But we do know that if you pass that protest date, that's going to trigger some legal deadlines that you want to make sure that you're protecting yourself. And, you might have to file in the Court of International Trade. Some companies don't want to do that. They don't want to be in the news like FedEx has been in the news. They want to make sure that, they're protecting their company and their brand as well. So I think it's a little early for anyone to be making massive decisions on what they're going to do. If you have a lot of money, again, speak with an attorney. They can guide you in what's best for your company in these specific circumstances. What I do know is that I think all of us are kind of at a point where we are missing what we knew before, but we know that's long gone. We might be okay, but we're not low at all. So we'll talk to you next week.